The state is, there is a DNA report pending in this case, and the defendant is currently out on OR bond.
Is there an offer being made in this case?
No, Your Honor.
Just one F5?
Yes.
What happened here? Just give me a brief summary. Allegedly.
The defendant was at Circle K on January 1st, 2025, and a bag of heroin fell in between two individuals while they were making coffee. It appears that it came from the defendant, but there is DNA on the bag, and we can't tell due to the camera angle whose pocket the bag fell out of, but there is DNA on it, and we are seeking those results.
Is the other person somebody that the defendant was with or knows, or is it just another stranger?
It's somebody that he was with. It was his brother, I believe.
Okay. Ms. Smith?
Thank you, Your Honor. We are in receipt of discovery, and Mr. Fintelli provided his DNA pursuant to that warrant today, just before we came onto the record. My understanding, a trial decision will be made based upon those results, and we do not anticipate any pretrial motions.
Okay. All right, Mr. Fantelli, nothing you need to do here today. You're good.
Okay.
I just need to advise you, on this pre-trial, I get together with the lawyers, find out what the case is about, see if there's any issues that need to be addressed before the ultimate trial date. Looks like there's one issue that's being addressed, but there's no need for any hearings. I need to advise you that you're on have been released on an owner cognizance bond. And that's being continued. We're not doing anything about that.
Okay.
But when you're on a known recognizance bond, you need to appear at all future court dates. And if you fail to appear at any future court date, that's a separate felony charge that you will be indicted on, which is actually more serious than what you're charged with.
Okay.
Which you can go to prison for up to 18 months on that, in addition to whatever would happen on here. So it's obviously important you show up at all your future court dates. Your trial date, which is the next court date as of this time, is October 14th of this year. Now, if this is going to be a plea to the charge, and I don't need to know that now, but I will need to know that 2 weeks before the trial date. So if the trial date is the 14th, I will need to know that September 30th.
Okay.
So in about 3.5 weeks or so. You don't call the court. You let your attorney. You and your attorney will talk. Your attorney, if it's going to be a plea, will contact the court and let us know that.
Okay.
If we don't hear from him by the 30th, that's going to be a plea, then it'll be a trial on the trial date. If it's going to be a plea, then it will be before October 14th. We will set a date before that date. I don't know that now, so I can't tell you what that date is. But I need to let you know that if it's going to be a plea, it won't be on the 14th, it'll be before that.
Okay.
So you need to make sure you keep in touch with your lawyer. If you haven't heard of a date, contact your lawyer. You can contact the court if you need to, if you can't get a hold of them.
Okay.
But it'll be before that date, and make sure you're here on that day, all right?
Alrighty.
Okay. Anything else we need to talk about, Ms. Smith?
Not on behalf of Mr. Fintelli.
Mr. Knopf?
No, Your Honor. Thank you.
All right, thank you all.
All right.
We're here today in the state of Ohio versus Antonio Askew, case number 25CR410. The defendant is present with counsel Tim Kuharski. We're set today for a sentencing hearing. We were last before you on July 7th, 2025, and at that time the defendant pled guilty to count 1, trafficking in cocaine, a felony of the 5th degree, to count 4, possession of cocaine, a felony of the 4th degree, and to count 5, having weapons under disability, a felony of the 3rd degree. At that time, a pre-sentence report and drug and alcohol evaluation were ordered. Those reports have since been completed. The defendant has 5 days of jail time credit, and the state would move to dismiss the balance of the indictment at this time. Thank you.
Thank you. Mr. Kuharski, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
I do, Your Honor. Mr. Askew is 54 years old, as you can tell from the pre-sentence report. And I'm not disputing what his record looks like, but I mention that because he is 54 years old. I think the important factors of the PSI and who Mr. Askew is that his last conviction was in 2008. He was released from prison in 2010. He hasn't had any other felony offenses that he's been convicted of since that time. So it's about 15 years during that period of time, Your Honor. During that period of time, he's been working, he's been employed, and most recently during this incident, he was working for Dyson. They were a steel manufacturer. He was working there. The police arrested him actually at Dyson. He was released from jail, and then he was terminated from Dyson. Now, I think an individual can do one of two things at that point. They can just say, oh yeah, I'm just going to continue to do what I'm doing. Or what Mr. Askew did is he went to a staffing program, just-in-time staffing. He was working and he's doing contract jobs for various staffing. He didn't just, woe is me and geez, that's the way it is and I'm going to go out and sell drugs and do everything else like that. Mr. Askew recognized that he's 54 years old. He's too old to be coming back to court. He's apologetic for what he did. Unfortunately, during this period of time that this incident occurred, Mr. Askew and his wife, who's in the back of the courtroom, they were having some marital problems. The individual whose house that they found him going to with Jessica Brothers was kind of his girlfriend at the time. So was Mr. Askew, and I think if you talk to Mr. Askew, he'll tell you that one of the reasons that he was having marital problems is he started using again. And so in the process of using, he was then selling a little bit here and there. He acknowledges his responsibility for what he did, understands that. But since that time, Your Honor, his drug tests have been clean. He's maintaining his sobriety. He's maintaining work. He's doing everything that the community and society would want an individual to do. And so I think it's also important to recognize that while there are controlled buys in this case, that there was never any use of a firearm. It's a status offense. We recognize that that's a crime nonetheless, but he didn't use it. He didn't brandish it. When they actually went to execute the search warrant, that's where they found it in the house. The gun, I believe Ms. Brothers indicated, was her gun. She had a receipt for it. She did everything for it. We're not disputing that he wasn't in possession of it because he was staying there on a periodic period of time. So he recognizes that, Your Honor. But I think when you look at the totality of circumstances, what this case really indicates is that Mr. Askew can lead a law-abiding life, as he's demonstrated for the past 15 years. What he needs is drug and alcohol substance abuse treatment. I think that prison, while he has been to prison before, I don't think that that is going to treat his drug and alcohol abuse issue. I think that and as the late Giaga had pointed out, a outpatient treatment would be appropriate. So I guess on the front end, I would say if you would allow Mr. Askew to continue going to a treatment program, he can keep working, he can do what he wants to do if you grant him community control sanctions. If the court thinks that, well, Mr. Askew, you've had some breaks, we want to make sure that you need to know what you're doing, we want to make sure you have the best professional, we would recommend the jail treatment program as well as NeoCap. I think that NeoCap would accept him. I think he's an appropriate candidate. I don't think a 54-year-old going to prison on these cases would be warranted. I think when you look under 29, 29, 11, and 12, it's the minimum sanction that must be imposed. I think that the community can be protected. Mr. Askew can be punished by the various sentences that I've set forth. So I would ask for either probation or NeoCap for Mr. Askew. Mr. Askew needs treatment, not prison, Your Honor.
Thank you, Mr. Kuharski. Mr. Askew, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say?
I'm just asking for help, Your Honor. I'm sorry, I messed up. I did wrong. I'm just asking for help. I'm sorry.
When's this going to stop? I mean, your lawyer said you haven't had a felony in the last 10 years. Fine, but you had 5 misdemeanors or so since you've been released. At least 1, 2, 3, 4, 5. Some of those were felonies that got reduced to misdemeanors. So they're ultimate misdemeanors. I get that, but they were reductions.
Yeah.
Like your lawyer said, you're 55 years old. When's this going to stop?
I'm going to stop now, Your Honor. I just asking for help.
All right. Mr. Kuharski, anything else you want to say?
Yes, Your Honor, I think I can answer the question. I think Antonio has stopped. I mean, this case has led him to realize that he has to abstain, he can't be using. And I think that when you look at his drug test that the probation department is providing them, I think there are at least 3 drug tests that he's taken that all become negative. So as to when it stops, I think it's already stopped.
I'm not necessarily talking about just using drugs. I'm talking about criminal behavior. It's been going on for 27 years.
I think that the lion's share, or the vast majority, is driven by his use and abuse of drugs and alcohol. And so I think that this fact that he's got the help of his wife, that his wife is supporting him, that he's doing everything that he can to maintain his sobriety is going to ensure that he doesn't use. That when you have that 15-year period of time, Your Honor, that's when he wasn't using. He has some problems, he starts using, and then he has a girlfriend and he's living at home and at the girlfriend's house. Things got out of control. Mr. Askew recognizes things got out of control. He just wants the help to make sure that he can maintain his sober lifestyle now.
Thank you. Ms. Bell, on behalf of the state of Ohio.
Thank you, Your Honor. I had the opportunity to review the pre-sentence report in this case, and while there are several disturbing things in that report, including the defendant's criminal history, his prison history, the fact that he has been allotted treatment in the past, the state does recognize that there has been a significant amount of time since he was in prison and has led a relatively clean up his act, relatively speaking. So the state would agree with the probation department's recommendation in this case. Thank you.
Thank you. Well, this court reviewed the pre-sentence report and investigation, the drug and alcohol evaluation. I've considered the facts and circumstances of the underlying offenses, the nature of those offenses. I've considered what's been said here in court today by Mr. Kuharski on behalf of his client, the defendant himself, the prosecutor, the recommendations from the parties. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11, for the factors in 29-29-12. Nothing stands out factually to the court that makes the offense any more or less serious than normal. As for recidivism factors, the defendant has a lengthy criminal history, includes juvenile delinquency history, and then an adult. He has previously served prison terms before, at least 2. He's been on probation before in the past, has violated his probation, which is a factor that shows he has failed to comply in the past with previously imposed sanctions ordered by courts. Nothing indicates recidivism. There's no factors present indicating it's less likely. Under 29-29-13b1, the court notes the defendant again has previously served prison terms, which overrides any presumption for community control. In considering the defendant's history, prison is certainly consistent with the purposes and principles of sentencing. But Mr. Askew, I'll give you one chance here. It's one chance. One chance.
Yes, sir.
I'm going to put you on community control sanctions for a period of 2 years. I'm not going to set you up to fail, though, and just say, go get your own outpatient treatment, because we'll be back here very soon. I'm going to give you what we have to offer. If you take advantage of it, use it to your benefit, then you should be good.
Thank you.
If you don't, then we'll come back, but I'm not going to, again, not give you the resources that we have. I'm going to order that you serve 60 days in jail. You have credit for 5 days. I'm going to order that you immediately get into the jail treatment program as soon as they can get you in there. Complete that program successfully. Upon completion, you are to enter and successfully complete the program at NeoCap once a bed is available after successful completion of JTP. Once that bed's available after that, he's to be released. Any balance of the jail time will be vacated. You're to complete the NeoCap program, follow all their recommendations. After NeoCap, you're probably not going to have to do this, but I put it in place for all. You're going to return to the jail for 30 days in the transitional day reporting program. Now again, you probably won't have to do this, but that's a program that helps people make the transition from being locked up to being on their own. Many people don't have anywhere to go when they get out of custody, and they're just lost and they have nowhere to go. So this is a program that you're in jail, but you're released during the day to find housing, find work. If those are in place when NeoCap's over, you won't have to do it. And that's something you can work on and make sure is in place while you're at NeoCap. But it's a good program for those that need the help, so I put it in place for everybody.
Thank you, Your Honor.
Further conditions then, you're not to use any drugs or alcohol. You must submit random urine screens. Those must be negative. A positive screen's a violation. You can't screw around with your urine sample, bring in fake urine, someone else's urine, tamper with it in any way. To attend 3 AA meetings a week and have a sponsor, obtain and maintain full-time employment. Pay your court costs and supervision fees. You have no contact with Jessica Brothers. I'm going to have you get a mental health evaluation. If there's any recommendations, I know there was some recent issues with that. If there's any recommendations for any type of counseling or treatment or medication, follow those recommendations. If there's not, then there's nothing more you need to do. Follow whatever recommendations are made in that regard. I'll dismiss the balance of the indictment. Counts 2, 3, and 6. Order bond be released. Megan, is there anything else I'm missing here or forgetting?
No, Your Honor, thank you.
So, Mr. Askew, you understand all the conditions of your community control sanctions?
Yes, sir.
Any
Your Honor.
questions for me?
No, sir.
All right, I need to advise you if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another crime while you're on probation, a motion to terminate your community control sanctions will be filed. And if it's found that you violated, I could technically extend your probation up to 5 years. I can impose more restrictive sanctions against you, which could include an order that you serve local jail time, or I could terminate your probation and send you to prison. And if I did that, it would be 12 months on count 1, 18 months on count 4, 36 months on count 5. That would all be consecutive. So that's 5.5 years in prison hanging over your head. You understand that?
Yes, sir.
All right. And you only get one shot here. There's going to be no review board contracts. That's something that takes the place of a probation violation and lets the probation department deal with it in-house. I'm telling them they're not allowed to do that here. If there's a violation, we're coming to court. You understand that?
Yes, sir.
All right. Mr. Karski, anything else you want to address?
Nothing at this time, Your Honor. Thank you.
Ms. Bell.
Nothing for the Honor. Thank you.
All right. Mr. Knopf?
Thank you, Your Honor. We are here on the matter of the State of Ohio versus Mark Downing, case number 25 CR 0000228. The defendant is present in open court with their attorney, James Reardon. We are set today for a sentencing hearing. The defendant has 2 days of jail time credit.
Thank you. Mr. Reardon, any reason not to go forward with sentencing?
Your Honor, I would make a motion, if the court is so inclined, that given the fact that you had revoked my client's bond earlier, perhaps you might consider rescheduling the sentencing hearing, perhaps coming back on another day, allow the pre-sentence report to proceed, and in the meantime, Mr. Downing can wait in the Lake County Jail.
I'm going to overrule that request. I gave Mr. Downing an opportunity to have a pre-sentence report. He was advised at that time that that was necessary in order for me to consider probation as an option, and that if he didn't show up for that, I wouldn't be able to put him on probation, and specifically that I wouldn't continue the sentencing hearing to allow him to get his pre-sentence report done because he failed to show up initially, and that's exactly what he did. And I'm not going to go back on what I told him. So I'm not going to continue the sentencing hearing at this time.
If I may, Your Honor, I was just handed today, if you're going to proceed to sentencing, a letter from my client's mother that she would like you to read, if you are so willing.
Sure. Give me a second. Okay, I've had a chance to review that.
Thank you.
Is there anything you'd like to say on behalf of your client?
Yes, Your Honor. In addition to what you read in the letter, which talks about some of the things that I would bring up, we are talking about a one felony 5 drug count. I do believe that Mr. Downing is very amenable to community control. I understand at this point that he's dug himself a bit of a hole for sure. I would ask the court, because he is gainfully employed, he is productive, he's certainly someone that could benefit from counseling, assessment, and treatment, that the court would consider a period of local incarceration and then, or community control with a component of local incarceration versus just sending him off to prison. I think that would not only benefit society, but benefit Mr. Downing, and ultimately is the result that best fits this situation.
Thank you. Mr. Downing, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you want to say at this time?
Yes, Your Honor.
Go ahead.
You're flabbergasted when I talk. No. I've had drug history for years and stuff, and I did some time in prison. So I was on heroin for a long time, and I haven't touched that in about 9 years. Since I came home, it's really hard to get back into society and start something over with after doing that time. Since then, I've started a business, and I've got 3 employees that everybody, 3 families that depend on me to keep them busy. My mom, she's got Alzheimer's right now, and my dad just passed away, and I don't know what's going to happen right here, but if I go away right here, everything's going to fall apart. Man, I've worked so hard to build my life back up. I've got issues now. The big thing is I've got severe ADHD. It's severe, and it affects my decision making like you have no idea. I mean, I can't even walk out of the house. It clouds my mind. It makes me make irrational decisions. Bad. It's gone untreated because I can't afford insurance, man. I keep busy. I work, and I work some more. I've lost every one of my friends to heroin addiction. I'm the only one left. So I keep to myself now. there's no excuse for the cocaine. You know, I did it, and I don't even like it. It's just, it's like it's a process in my head that I guess it's wired in there. You know, I make a bad decision every now and then. I don't know how to correct it. I don't. You know, I've tried everything. I've tried any class that everybody has. I try to focus on doing the right thing, man. I really do. I treat everybody with respect, and I keep people busy. But sometimes I got some issues. I'm not a perfect person. The biggest, if I go away for a long time, it's my mom issue. I don't know what's going to happen to her.
Well, why don't you show up to the probation department?
Because I pissed 30. And when I pissed 30, I'm in the middle of a job right here. I work so hard to get these clients right here.
Well, you were told what would happen. You made that choice.
Again, it's not like I go out to do it. It's just, I can't control it. I can't control my decision making. It's not the drug habit. I don't even like it. I don't even do it that often. I get these sporadic thoughts in my head, and it just, I can't stop. I can't stop it.
You've got other charges pending against you too for drugs.
Same thing.
You say you don't do it that often. You don't probably get 2 felony charges pending against you when you were caught.
I'm just letting you know the situation. Do I like it in my problem? No, I don't. I don't know where else to go. I try to work on everything. I'm stuck. I'm stuck. This is as honest as I can give you, man. Your Honor, it really is. I don't know what else to do.
Anything else you'd like to say?
That's
I
it.
mean, you don't have to. I just make sure you said
No,
whatever
that's
you
it. I
want.
appreciate it.
Mr. Reardon, anything else?
Nothing further, Your Honor.
Mr. Knopf, in the state of Ohio?
Thank you, Your Honor. At this point, the defendant has failed to appear at his pre-sentence report. The defendant violated the conditions of his bond by submitting a positive urine screen, and the defendant has previously served a prior prison term for offensive violence, so the state would be asking for prison.
Well, this court has considered the particular facts and circumstances of the offense involved, the nature of the offense. There was no pre-sentence report completed in this case because the defendant failed to appear to the probation department for his interview, never contacted them, never contacted anyone. So there is no pre-sentence report or drug and alcohol evaluation available for the court's review. I've considered what's been said here in court by Mr. Reardon, the defendant, the prosecutor, recommendations. I received a letter just this morning from the defendant's mother that I read. I've taken that into consideration. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11. So the factors in 29-29-12, nothing stands out factually. Indicating the offense is any more or less serious than normal. As for recidivism factors, the court finds the defendant has a history of criminal convictions. He has previously served a prison term before in the past. He was on probation to this court after serving a prison sentence. The court granted his motion for shock or judicial release, which is rare. But he violated that and went back to prison, so he's failed to comply with previously imposed sanctions ordered by courts. There's a drug abuse problem that relates to the offense, and he hasn't done anything to address it. Failed to appear at probation department for his interview, as ordered to do so. These are all factors indicating recidivism is more likely. Nothing indicates it's less likely. Under 29-29-13b1, the court finds defendant has again previously served a prison term, which is a factor indicating recidivism, which is a factor overriding the presumption for community control sanctions. Prison is consistent with the purposes and principles of sentencing. This court doesn't have the authority at this time to place him on community control without a pre-sentence report. Based on the history and everything I've said, he's not amenable to community control sanctions. Therefore, it will be the sentence of this court that on count 1, defendant serve a term in prison of 8 months He has credit for 5 days he's already served. Counts 2, 3, 4, and 5 will be dismissed. I need to advise you upon your release from prison, you may be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, there's 2 days of credit, not 5, 2 days of credit. If you violate any of the conditions of your post-release control, the parole authority can return you to prison as punishment for violating the rules for another 4 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control, and order the forfeiture of the contraband and instrumentalities. The defendant's ordered to pay all costs. Is there anything else for the record, Mr. Knopf?
No, Your Honor.
Mr. Reardon?
Nothing further, Your Honor.
He's going to help you scoot the chair in.
We're present in case 22 CR 129, State of Ohio versus Eloise Darden. We're here on a scheduled probable cause hearing on a motion to terminate community control sanctions filed by the State of Ohio. Defendant is here in court with counsel, Ms. Catherine Purdom. Is it Purdom? Is that correct?
Purdom.
No, how do you say it?
Pardon?
How do you say it?
Purdom?
Purdom, all right, that's what I
Yeah.
said, all right.
Yep.
Ms. Purdom, what is the defendant's intention at this time regarding the hearings?
Your Honor, at this time, Ms. Darden is interested in admitting to the violation and moving forthwith to disposition on that violation.
So she'll waive the hearings that she's entitled to have?
Yes, Your Honor.
Ms. Darden, you are charged with violating the conditions of your community control sanctions. Specifically, it's alleged you violated Rule 8, which prohibits you from using, possessing, or having under your control any controlled substance not prescribed to you by a licensed physician. It's alleged specifically that you submitted a urine sample on August 14th that tested positive for marijuana. Now, you have the right to have actually a couple of hearings regarding this allegation. The first is what's called a probable cause hearing, which is a hearing where the State of Ohio will be required to present some evidence to suggest you probably committed this violation. You then have the right to have a final hearing on the merits. Now, it will be on a different day and time to give you time to prepare if that's what was you wanted. And that is a hearing where the state would have to prove the actual merits of what they're alleging. Now, you could have either or both of these hearings, or you could waive the hearing and plead guilty to the violation. And your attorney has indicated she believes that's what you want to do, waive the hearings and plead guilty. Is that correct?
Yes.
Well, before I can accept your waiver and your admission, I need to make sure you understand potential consequences you face if you're found to have violated your community control sanctions. If in fact that did occur, the court could extend your probation up to a total of 5 years. It was originally have we extended it at all or not?
Yes, Your
Oh yeah, I see that 1 year. It was originally 2 years. It was then extended to 3 years. The last probation violation, so I could extend it up to another 2 years. I could impose more restrictive sanctions against you, including an order that you serve more time in our Lake County jail, or I could terminate your probation and send you to prison. And if I sent you to prison, it could be anywhere between 6 to 12 months in prison. Do you understand the potential penalties you face if you're found to have violated your community control sanctions?
Yes.
Well, having been so advised, what do you want to do at this time? Do you want to have either of these hearings, or do you want to waive both hearings and plead guilty to the violations, or violation, I should say?
Waive and plead guilty.
Very well, then as to the allegation that you violated Rule 8 by using marijuana, what's your plea to that?
Guilty.
All right, the court will accept your plea of guilty, find that you did violate your community control sanctions. Ms. Purdom, any reason not to go forward with sentencing?
Not that I'm aware of, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, thank you. Ms. Darden was sentenced in 2022, or this case originally started in 2022. I know that there have been other incidences of violations where either she was truly violated or there was a meeting to help give her more support. I know Ms. Darden is feeling the effects of having to be here on another violation today. She is concerned for her daughter and making sure that she is available for her. I know Ms. Darden has a lot of support in her life. She has a social worker from the YMCA, Ms. Black, who is helping support her and get her to her hearings, her probation meetings, and attend to other necessities in her life. I know that Ms. Darden's road through this has not been the easiest, and that she is looking forward to being able to move forward from this with all of these concerns in mind. Although this is not the first violation, this violation at least, she was negative 2 weeks prior, then on the 14th tested positive, and was negative again on August 28th. It seems with the nature of marijuana that if she was using consistently, she would have tested positive on the 28th as well, but I know that this was shortly after she was released from the jail treatment program and completing an IOP. We'd ask the court to take it into consideration that she did test negative on the 28th, therefore this marijuana was not a consistent use. And I guess see that this is not an issue that will continue to be an impediment that would be if she was in active use with marijuana. We ask that the court consider allowing her to go to a residential facility, either Oak House or Nevaeh Ridge, as soon as possible with availability at either location. Ms. Darden is, I think, feeling the effects of not having her daughter with her more so now than she has in the past, and is missing out on her daughter's school, and is looking forward to being able to create stability for her daughter and continue to move forward from this incident. Thank you.
Ms. Darden, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you want to say at this time?
No.
Well, you know, you hold the keys to being with your daughter and being able to do everything. And you may think it's a petty violation, not smoking marijuana, but it's something that you're not supposed to do. And you're making a choice to do it, knowing what the consequences are going to be. You do it, they're going to catch it. You're not going to get away with it. And you're going to be separated from your daughter, which is probably worse than going to prison.
Yeah.
So you're making that conscious decision. And you've made these decisions. This is the third violation you have. First one, they gave you a break. They didn't violate you, but they did a review board hearing because you used marijuana. Then the next one, you violated, you failed to report. Be able to do any of the conditions I ordered you to do. Then when you got arrested, you tested positive again. So you said you don't have a problem with marijuana, but you've tested positive at the time with the review board hearing when they gave you a break, just shortly after you got out of jail in the original. Or no, I didn't even order you to do jail originally, which is extremely rare. But you tested positive shortly then. Then you violated your probation and you didn't show up and you were gone for a while. When you got arrested, you tested positive for marijuana. And you got out of jail here, and within a month, you tested positive for marijuana again. Now, claim you don't have much of a problem with it or you can control it because you were negative shortly thereafter. I don't see that. You've tested positive 3 times with us. There's an issue there. And in particular, when you know that if you use, you're being separated from your daughter. And you still use anyway. It's got to be that there's a problem. I don't know what more to, I mean, you're acting like you don't think you need to follow the rules that court orders. Like when you're done with whatever jail time, you get ordered that your sentence is over with and you can just go about your business. You're on probation. Now, if you want to do it that way, we do it that way, and you go to prison, you serve your time, and then you're done. You can do whatever you want. But if you want to be on probation, it's more than just serving some time in jail and then walking out of jail. There's conditions you need to follow. And we don't just put these in place for the heck of it. We put them in place to try to help you and try to get back on track. And you may think marijuana is not a big deal, but first of all, it leads to other things. Second of all, you're spending money that you probably don't have. Thirdly, it's going to cause problems. It's going to cause you additional problems. I guess guess the choice is yours, and it seems like the choice you're making is that you don't want to follow the rules that we have here. You don't think you should have to. You think they're foolish, unnecessary. But if you're going to be on probation, you have to do it. So what do you want to do?
Do the probation. I will stop or refrain from it. I cannot be away from my daughter again.
You need to appreciate the consequences of it. Again, you may think, marijuana is legal now, I should be allowed to use it. But the consequences for you are that you're separated from your daughter. You make that choice from that going forward. I'll give you one last chance, but I'm not going to keep doing this. I've considered all the information I previously had, the pre-sentence report, drug and alcohol evaluation, defendant's performance on probation, the nature of the violations, the nature of the original offenses. I mean, you were given a break at the beginning. I didn't order any jail time. I rarely do that. Rarely. I'll incorporate all the findings I've made regarding the seriousness factors, recidivism factors, with the additional finding the defendant again failed to comply with the previously imposed sanctions ordered by the court, which is a factor indicating recidivism is more likely. I'll find at this time that while prison is consistent with the purposes and principles of sentencing, this court's view, the defendant is still amenable to an available community control sanction. So I'm going to give her one last chance. I'm going to continue on community control sanctions. I am going to extend it 6 months because we need that additional time with this program. I'm going to order how much credit is there in the violation?
12 under violation.
I'm going to order 72 days in jail with credit for 12. However, so 60 more days. But however, I'm going to order that you enter and successfully complete the treatment program at either Oak House or Nevaeh Ridge, whichever has a bed available first. As soon as that bed's available, you can be released from the jail to go to that facility. Any additional remaining time will be vacated. You don't need to come back and do that. You're to go to the treatment program, successfully complete it, follow their aftercare recommendations. The other orders are going to be the same as that was in place before. Not to use any drugs or alcohol. That includes no marijuana. To submit random urine screens, those must be negative. Positive screens a violation. Did JTP recommend AA meetings for her? And we'll follow whatever recommendations, if any, are made by the residential facility regarding AA meetings. If they recommend them, you need to do those as a condition of your probation. If they don't, then you don't need to. To obtain and maintain full-time employment, obtain your GED or provide proof that you did get it, obtain mental health counseling, take medications as prescribed. These are all the same conditions that you had before. 1 doctor, 1 dentist, 1 pharmacy. I'm going to eliminate the condition I had about the community service. Did you do any of that?
I didn't finish. I think I got like 12 hours left. I was going with my aunt.
You think you have 12 left?
12 hours left.
All right, well then I'll require you, I'm not gonna add, make it a full 30. You
Okay.
finished the 30 hours that you had, so
Okay.
make sure you provide proof of that. Do you have any proof of any community service?
No, not as of now.
Well, what do you have something that shows that?
Yes, it was a paper I originally got from Jamie. I asked Brittany, this 14th, to give me another paper, like a community
Who's
service.
Brittany?
I think her name is Brittany, the lady that did my screen on the 14th of August. What's her name?
There's no Brittany over there. But
I,
someone in the probation department?
yeah, she's a probation officer. She's the one that did my screen. She gave me another paper to finish.
But you said you provided a paper to somebody that had proof of your hours?
No, she's seen it on my phone, but I don't have proof. Like the physical paper, I didn't bring it that day.
Do you have proof of the hours that you've already?
It's at home, yes.
All right. Well, then you need to provide that to them. Right now, you owe us 30 hours.
Okay.
Anything that you've done already, I'll give you credit for, but you need to provide that proof.
Okay.
All right? So the original 30 hours of community service, less any, with giving her credit for whatever hours she's already done. Your court costs and supervision fee, all the same conditions that, and once you get out of the residential treatment, it's the same thing that you've been ordered to do. Did she pay restitution? Yeah, I don't have it the same thing. So Ms. Darden, you understand the conditions of your probation?
Yes, I do.
Derek, anything else I should be thinking about?
No, thank you.
I need to advise you that if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, if you commit another crime while on probation, another motion to terminate will be filed. If it's found that you violated, I could extend you up to another 1.5 years on probation. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it'd be 12 months in prison, and that'd be consecutive to any other case that you may be serving, or term you're serving, or being sentenced to for if there's a new case. You understand that?
Yes, I do.
I'm not going to be able to do anything else here if you come back. You understand that?
Yes.
This is going to be the last chance you get. Ms. Purdom, is there anything else you want to discuss?
I don't believe so, just that she will provide documentation of her community service hours and her completion of her GED.
Yeah. If she's done it, if you've done it, made the effort to do it, you're foolish not to. They're not going to just take your word for it. You need to provide the proof, and then you check that off the list. It's one less thing you got to do. So don't hesitate in doing that, or wait in doing that. All right?
Yes.
You have any questions?
No.
All right. Good luck.
Thank you.
We're present in the matter of State of Ohio versus Leland Talley, case number 25CR000475. The defendant is present in court with defense counsel William Mooney. We are here for purposes of a sentencing hearing. We were previously in court on this case on July 28th of 2005, where the defendant waived his right to have his case presented to a grand jury and pled guilty to a one-count indictment, that one count being attempted having weapons while under disability, a felony of the 4th degree, in violation of revised code sections 2923.02 and 2923.13A2. The defendant was found guilty and the court ordered a pre-sentence investigation and report. The state has had the opportunity to review that report and is prepared to proceed with sentencing today. Thank you.
Thank you. Mr. Mooney, any reason not to go forward with sentencing?
No reason, Judge.
Anything you want to say on behalf of your client?
Thank you very much. I've had a chance to review the pre-sentence investigation report as well, and I didn't notice any technical defects or anything other than it's true and accurate depiction. Leland is 46 years old, Your Honor. He's here with his wife in court today, Shayla, his wife of 4 years. They live in South Euclid with two of Leland's sons, or two of Leland's children. Leland owns a business, Your Honor. He owns a cleaning business, mostly commercial, some residential. On the day in question, he was on his way from work and passing by a gas station to pick up milk for the next day when the crime was committed. He did openly and freely and voluntarily admit to the crime he committed that day, Your Honor. It is a 4th degree felony. It does carry a presumption of probation. We would be respectfully asking for a term of community control. I will say, Your Honor, that Leland has been a very cooperative client. He's always appeared promptly, on time. I don't believe he has any history that I'm aware of, and any non-compliance with any court orders, parole or otherwise. He does have, speaking of parole, he does have one prior felony. And other than that, he does have a minimal juvenile record. I also will say, Judge, that as far as cooperating with this court and with me, he's been cooperating or cooperative with the lead detective in this case, the Detective Burrington, who on my first day, our first day in court, in the municipal court, Detective Burrington, and this was mentioned at the plea hearing, Your Honor, was interested in a low-level type of plea deal. However, we did end up here. Leland, as the court is aware, did step up and agreed to proceed through information, certainly for purposes of streamlining the process. That certainly helped. Your Honor, last thing I will say is I don't believe that Leland would be anything other than fully compliant with any terms of probation or community control. And other than whatever Leland has to say, I think I will leave it at that, Judge. Thank you.
Thank you. Mr. Talley, you have the right to address this court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yes, Your Honor. I just want to say that on that night, I want to apologize about that night, but I just felt that at that moment, I felt like I had to do what I had to do in the situation that I was in, coming from a contract that I was at. It was 3 o'clock in the morning. I stopped to get some milk for some cereal. I just bought some Fruity Pebbles. They had introduced the new marshmallows to them. And I was like, okay, I'm going to stop, give me some milk. That way in the morning I'll have breakfast. So when I went to the gas station, my thing was to get in and get out. But see, I knew something was wrong. When I entered the gas station, I was getting the milk. I saw the young guys. Now my thing is, I knew why I was there, but listening to them talk, I knew why they was there as well. So on my way leaving the gas station, one of the young guys was blocking the door with a young lady. I didn't want to say anything to him, Your Honor, because I know what it can lead to, so I just stood there. Till the young lady noticed me and said, hey, he's trying to leave the store. And when he turned around and seen me, little young guy, he said, well, he need to open his damn mouth then, but he still let me proceed to leave. So as I was leaving, I walked out, I said, man, all this over some milk, but they were behind me. And the young guy said, "What did you say?" I said, "No, I'm talking about some milk, taking my milk home." You know, he was like, "Well, take your ass home then," which that's what I was doing. So as I got in the vehicle to leave, I heard him say, "Let's take that damn truck. We taking that truck. Let's get the truck." So when I stopped, I tried to talk. I said, "Hey, look, I don't want no problems. I'm just trying to, you know what I'm saying?" Go. They're like, "No, go home. Go ahead, go ahead." So when I got back in the truck, because like I said, I was trying to get the attention of the people inside because I was on my way leaving. I didn't want to go back that way because I don't know what they were going to do. So as I got back in the truck, they started up to come behind me. And that my first instinct was get their attention. So when I got their attention, my attention was to get their attention and leave. That way, if anything ever happened to me, my wife, everybody would know. I didn't want to be an unsolved mystery. I know how these young guys think. I come from where they come from. So me doing that was only me going home. I meant to harm no one. I wasn't trying to harm no one. I was just trying to get home to my family. That's all I was trying to do, Your Honor. That's it. So I would like to apologize to everybody in the court that's here right now because of me. I just want to apologize because you guys can be doing anything else besides sitting here with me.
Thank you, sir. Mr. Mooney, anything else you'd like to address?
The last thing I would say, Your Honor, is that I had some in-depth conversations with Leland about the fact that he had a gun in the car, being a prior felon. Obviously, he's not ignorant of the law. I'd feel very confident that this is not something that's ever going to happen again. I mean, I think, you know, there is a reason why, you know, people in dangerous communities do things that they know are not the right thing to do. And I would just say after my conversation with Leland and his wife that, you know, I can't imagine that anything like this will ever happen again.
Thank you. Ms. Ronick, on behalf of the state.
Thank you, Your Honor. As part of the plea agreement, the state did enter into a joint recommendation to recommend community control for the defendant. After reviewing the pre-sentence report, the state believes still that joint recommendation for community control is appropriate. The defendant has been very cooperative from the very beginning, was cooperative with the probation department, and other than the conviction for which he went to prison in 2009, does not appear to have any other prior convictions, so the state does not believe there's any reason to believe he's not going to be amenable to community control, so the state is asking that the court impose a community control sentence. Thank you.
Thank you.
If it's appropriate, Judge, I have one more thing, sorry. I know we had some discussions about this license issue, the license suspension. Leland was not aware. He had just, and his wife, neither of them were aware, but I've advised him that as soon as practically possible to go to the BMV and get that cleared up because he was not aware that his license was suspended.
Well, if it's BMV or South Euclid, he should go to, but.
Or South.
Try to go to South Euclid.
Yeah, because his license is showing up.
Makes no sense.
No.
Well, I'm not considering that for any reason.
Understand.
Other than he needs to get it straightened out. But this court has reviewed the pre-sentence report and investigation. I've considered the facts and circumstances of the offense involved, the nature of the offense involved. I received a couple of letters this morning. I read and considered those. I've considered what's been said here in court by Mr. Mooney, the defendant himself, the prosecutor, the recommendations. All of this is considered by the court in light of the purposes and principles of felony sentencing set forth in 29-29-11. As for the factors in 29-29-12, I do note that in terms of making the offense more serious, that the defendant actually discharged the firearm multiple times. Witnesses said 5. They found at least 2 shell casings, so we knew it was at least 2 times. That makes it more serious than the normal weapons under disability case. The normal weapons under disability case does not involve firing the firearm. It doesn't even usually involve it being in the possession of the person's on their body. Usually it's found in a car, in a glove compartment, in a console, somewhere near the person. Doesn't involve shooting the gun, but this case does, which makes it more serious. Nothing makes it less serious. As for recidivism factors, the court notes that the defendant does have prior criminal record, one prior felony, albeit a very serious one, felonious assault with a firearm specification. He served 4 years in prison, but that was in 2009 when he was convicted and sentenced, released in 2013, successfully completed PRC in 2014, and nothing since that time. That case involved a firearm as well. As for factors indicating recidivism is less likely, the court notes that the defendant has led law-abiding life for a significant number of years. Again, that was occurred in 2009, so what are we now, 16 years later? And he does show and demonstrate genuine remorse that comes from everybody, from the original officers. Prosecutor believes it, probation believes it. So I'll make that finding as well. So felony of the 4th degree, normally there's a presumption for community control. However, that is overcome in this case as a result of the defendant having previously served a prison term, and that the offense involves a firearm. That overrides the presumption for community control sanctions and permits the court to impose a prison term without having to provide any explanation or findings. Prison, however, is not consistent with the purposes and principles of sentencing in this case. Then it is amenable to an available community control sanction. Therefore, it will be the sentence of this court, the defendant be put on community control sanctions for a period of 2 years. I'm going to order the defendant serve 30 days in jail. He has credit for 1 day he served. I can't ignore the fact that you shot a firearm multiple times in public this establishment as you're leaving. That can't be ignored. He fired a firearm in public. Quite frankly, 30 days in jail is probably in the low end, but that's all I'm doing. Further conditions: not to use any drugs or alcohol, must submit random urine screens. They have to be negative. Positive screens of violation. You're not to possess in any manner any firearm. In order that you complete the decision point program. You perform 30 hours of community service. Maintain full-time employment. I'm going to order that you get this license straightened, the driver's license issue straightened out. If it technically is suspended, I'm not, don't in one way believe that you know it or you knew this, but you can't be driving on it if you know it now, and you got to get that resolved. Pay your court costs and supervision fees. Randaz, anything else I should be considering?
Nothing further, Your Honor.
Your Honor, I would ask respectfully, if possible, since Leland does have own his own business, he has people that he's responsible for, work schedules, etc. A couple things.
Let me finish the sentence first.
Oh, sorry, Judge. Okay.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from this court, or if you commit another crime while you're on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it'd be 18 months in prison. So that's what's hanging over your head. You understand that?
Yes, Your Honor.
All right, Mr. Mooney?
Oh, thank you, Judge. So with respect to the 30 days local time, I'd ask the court to consider possibly either a turn-in date or work release or something, so that Leland, understanding he has to, obviously pay for the crime, to give him an opportunity to at least not have the people he worked with suffer and his business to continue, even though it's going to continue for 30 days. That's somewhat of a...
Well, that's something that should have been addressed before then. This is the sentencing date. It's been in place since July 30th. He was advised on that day that he would prison for 18 months or he'll go to local jail time. I've taken into consideration the sentence I'm imposing is much less than probation even recommended with work release. So I'm not going to alter the sentence I just imposed.
Understand.
Mr. Ronick, anything else for the record?
No, Your Honor, thank you.
Thank you, Your Honor.
afternoon, Your Honor. We are hearing case 25-CR-434, State of Ohio versus Brian D. Wilson. Present in court is the defendant, who's accompanied by his attorney, Ms. Nicolette Tomazik. We were previously here on July 28, 2025. At that time, the defendant withdrew his previously entered pleas of not guilty and entered a plea of guilty to count 4, aggravated possession of drugs, a felony of the 5th degree, and count 5, tampering with evidence, a felony of the 3rd degree. This matter was deferred for sentencing and referred to the Lake County Adult Probation Department for a pre-sentence investigation report, as well as for a drug and alcohol evaluation. Those reports have been completed. The state has had an opportunity to review those reports and is ready to proceed with sentencing. The state would move to dismiss the remaining counts of the indictment at this time, and there are 78 days of jail time credit. Thank you, Your Honor.
Ms. Thomas, any reason not to go forward with sentencing?
No, Your Honor, we're prepared to proceed with sentencing.
Anything you'd like to say on behalf of your client?
Yes, thank you, Your Honor. We would like to ask the court to allow Mr. Wilson an opportunity to be placed on community control sanctions. I know Mr. Wilson has been in prison in the past in 1998 and again in 2006, but he would like an opportunity to be placed on community control today. And speaking with Mr. Wilson, he has been advocating very hard for himself in the treatment that he needs. He wants to do as much treatment as possible, Your Honor. Prior to this, he was doing IOP. He initially thought that would be enough for him, and then, Your Honor, his bond got revoked, and that's when he realized that he has a bigger issue than he realized. He hasn't done treatment in the past because he didn't think he had much of an issue up until recently, Your Honor. I think the fake urine really set it in stone for him. When I spoke to Mr. Wilson, he indicated to me first thing up front he wants to do jail treatment program, Your Honor. He wants to do NeoCap. He wants to do residential. He wants to do sober living. He wants to make sure he is set up for success. Where he was living, drugs were easily accessible. He will no longer be living there. And that's why he wants to do the sober living, to make sure he can set himself up, have somewhere to live, and eventually find a much better place to live and try to not hang out with the people that he was hanging out with. He liked the treatment aspect of it. He just indicated he needs a little bit help telling people no and being around better people. So we'd just like to ask the court today to give Mr. Wilson an opportunity on community control sanctions and allow him a chance to do treatment, Your Honor. Thank you.
Thank you. Mr. Wilson, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
I just would like to say I'm sorry, and that, yeah, as much treatment as possible would be appreciated from the court.
Time, is there anything else for the defense?
No, Your Honor, thank you.
Simone for the state of Ohio.
Thank you, Your Honor. Based on the defendant's criminal history, which largely does include a number of offenses for drugs and alcohol, he does have 2 prior prison sentences, as Ms. Tomazik indicated. He has been ordered into treatment at least one other time, and that was back in 2021 after a probation violation in Willoughby Municipal Court. But it doesn't appear he's had other treatment aside from that. He did violate the conditions of his bond by testing positive for amphetamine and methamphetamine, as well as bringing in either old or fake urine. But based on the facts and circumstances of the case, the state does recommend that the court impose a sentence of community control sanctions in this case, including local jail time and treatment. Thank you, Your Honor.
Thank you. This court reviewed the pre-sentence report and investigation. Excuse me. Drug and alcohol evaluation. I've considered the facts and circumstances of the offense involved and nature of the offense involved. Consider what's been said here today by Mr. Wilson himself, his lawyer, the prosecutor. I received some letters in support of Mr. Wilson. I've read and considered those. All this is considered in light of the purposes and principles of felony sentencing set forth in 2911 of the revised code. As for the factors in 2912, factors indicating the offense is more or less serious. Nothing stands out factually indicating it's more or less serious than what normally constitutes the commission of this offense. As for recidivism factors, court finds the defendant has a history of criminal convictions. He has previously served 2 prison terms before in the past. He has not responded favorably in the past to previously imposed sanctions. He has been on probation before, and he's violated his probation before in the past. Committed this offense with a warrant out for his arrest out of Shaker Heights Municipal Court. He further violated the conditions of his bond and using drugs while on bond and then trying to perpetrate a fraud on the court and probation department by bringing fake urine in, which he had on him during his plea in this case. There's no factors indicating recidivism is less. Well, if I go back to recidivism factors, there's also a drug abuse problem that relates to the offense. And he acknowledges it, indicates he wants treatment, but he hasn't done anything in the past to address this. He doesn't need to commit felonies to be ordered to get treatment in order to get treatment. No factors indicate recidivism is less likely. Under 2913B1, the court finds the defendant, again, previously served a prison term. That overrides any presumption for probation, permits the court to impose a prison sentence without having to make any special findings. Based on the defendant's history, and what I've outlined with the recidivism factors, prison is certainly consistent with the purposes and principles of sentencing. The question is whether you're amenable to available community control sanctions, meaning whether you are going to follow the rules of probation and work at the programs that you're in, take advantage of those programs. I've been doing this for a long time. Again, you haven't done anything to address the issue. I will find that you're amenable to an available community control sanction and give you a chance, but I'm going to give you what you're basically asking for, every resource we have here. If you can't succeed with this, there's going to be nothing else we can do for you, quite frankly. You're going to be tied up for a while. They're good programs. If you work the programs and take it seriously, you got a big head start in getting back on track. So I'll give you that chance. I'll find that you're amenable to an available community control sanction, and I'll place you on community control sanctions for a period of 30 months. I'm going to order that you serve 140 days in the Lake County Jail. You have credit for 78 that you've served. I'm going to order that you immediately get into, as soon as the bed's available, into the jail treatment program. Complete that program. After completion of the jail treatment program, I'm going to order that you be released when a bed is available at NeoCap to attend NeoCap and successfully complete that program. Follow all their aftercare recommendations. I'm then going to have you return to the jail. You're probably not going to have to do this, but 30 days for the transitional day reporting program. And you may not have to do that, but that's a program that helps people make the transition from being locked up from custody to being on their own. Many people have nowhere to go when they get released from custody. So they're put in the jail, but they're released during the day to try to find housing, try to find work. And when they do, then they're released. If you have housing set up and work set up and you don't need this assistance, I'll vacate that 30 days. You won't have to do it. But it's a nice program for people that have that need. Upon release from NeoCap, I want you to reside in a sober living residence for at least 6 months. Stay longer if you want, but at least 6 months. Further conditions: you're not to use any drugs or alcohol. Submit random urine screens. They have to be negative. Positive screens a violation. To attend 3 AA meetings a week and have a sponsor. To obtain and maintain full-time employment. I didn't mean to do probation for 2 years, not 30 months, 2 years. Obtain and maintain full-time employment. Pay your court costs and supervision fees. I want you to obtain a mental health evaluation at some point and follow whatever, if any recommendations are made for any type of counseling or treatment. If they don't say anything is necessary, then you're done. If they say counseling could help, then you need to do that. I'm going to dismiss the balance of the indictment. Kaylee, anything else I should be thinking about here?
Yeah, if you'd just like to consider one doctor, one dentist from pharmacy.
Yeah, I'll do that too. And what was the last thing you said?
Sign releases.
Yeah, you're only permitted to have one doctor and one dentist that could prescribe you medication. If you have a specialist, that's fine too. But you can only get prescriptions from those doctors, and probation needs to be advised who those doctors are. Provide whatever releases they need if they need to reach out to those folks. You can only get your prescriptions filled at one pharmacy as well, and you need to know where that pharmacy is. So if you get prescriptions from some other doctor, even if it's legit and they don't know about it, or you're filling them at different pharmacies, that'd be a violation. You understand that? All right, Mr. Wilson, you understand the conditions of your probation?
I just have one question. You said when I get out of NeoCap, can I just go right into sober living?
Yeah.
It seems redundant. Okay, so 'cause I know about that 30-day program, but that just seems.
Well, it's got to be, it's there, so maybe you can't get into sober living right away.
Okay, right on.
Then you're going to remain in jail till that is available.
Okay.
Very well, if you at NeoCap, if you work on that and it's all set and it coincides, then it'll be done. You very well may have to do it, but maybe there's some gap in time when you can get in, and then I'm not going to have you out and about until you're going in there. So that's the point of that. Any other questions?
No, sir. No, Your Honor.
All right, I need to advise you if you fail to comply with. Oh, I'm sorry. I want another condition is that no contact with Jordan Walter. I need to advise you if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, question? Or what?
Sorry, Judge, he just wanted to confirm the no contact.
Yeah, that's a condition of probation as well. She's a co-defendant here, right? And that's who he was with when this was happened. Did I get the right name or did I get the wrong name?
I don't believe there was a co-defendant in this case, Your Honor. I know he was with another individual, but I don't believe they were charged to my knowledge.
Well, he's had no contact with Jordan Walter. You understand that? Why is that an issue?
I don't understand. She doesn't use drugs or ever been in trouble. She didn't know that I had the mushrooms on me. She was simply the driver of the car. They searched me because I wasn't.
Well, she's married, isn't she? I mean, what's the relationship there?
It's just we've been friends for a long time. I just don't understand why not to have contact.
You were with her at the hotel. You were clearly under the influence when the police stopped the car and arrested you. You're gonna have no contact with Jordan Walter. You were there using drugs when you were there using drugs with her. Maybe she wasn't using, but she clearly had to know. That's a condition. You need to advise you if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from this court, or if you commit another crime while you're on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. And if I did that, it would be 12 months on count 4, 36 months on count 5, consecutive for 48 months in prison. That would be consecutive to any other sentence you're serving for some other case or that you're being sentenced to at that time. The balance of the indictment is dismissed. Any bond that was posted is released. We're not forfeiting the bond. Similar, is there anything else for the record?
No, Your Honor.
Ms. Tomaszek?
No, Your Honor, thank you.
All rise.
Thank you, Your Honor. We're present in case State of Ohio versus Blaine Snyder, case number 25 CR 634. The defendant is present today in court represented by attorney Jim Matthews. We were previously in court on August 4th of this year. The defendant pled guilty by information to aggravated possession of drugs, a felony of the 5th degree with a forfeiture specification, as well as misdemeanor theft, a misdemeanor of the 1st degree. This matter was then referred for a pre-sentence report and a drug and alcohol evaluation, and we're scheduled for sentencing today. Thank you.
Thank you. Mr. Matthews, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, thank you. Your Honor, given the fact that Mr. Snyder does have multiple warrants for his arrest, him requesting any kind of probation or treatment would likely be impractical. So he is asking the court to consider a prison sentence of 7 months. He only has credit for 2 days, despite the fact that he's been in jail approximately 4.5 months on various municipal court sentences. Given the fact that he has been incarcerated for 4.5 months and that he does indeed face further sanctions from both Cuyahoga and Ashtabula County, he does feel that the recommendation of 7 months is appropriate and would ask that the court consider all those factors, Your Honor. Thank you.
Thank you. Mr. Snyder, you have the right to address the court before your sentence. You can say anything you'd like. Is there anything you want to say at this time?
Other than I'm take full responsibility for my actions. I mean, I'm not going to give any excuses. I mean, other than that, I mean, he's pretty much said everything for me.
Okay. Mr. Matthews, anything else?
No, Your Honor.
Ms. Wood for the State of Ohio.
Thank you, Your Honor. On behalf of the State of Ohio, I am recommending 11 months in prison on this matter. The defendant has a lengthy criminal history dating back to the 1990s. He has 2 prior prison terms for his prior criminal convictions. He was on community control for 2 different offenses in 2 different courts at the time that this offense was committed. And the pre-sentence report notes very limited treatment to address any substance abuse. The most recent, I believe, was in 2021, so the defendant has not engaged in any recent treatment to address any mental health or substance abuse issues, whether or not they were court-ordered. He's been given an opportunity in the past for community control. He's violated. This court gave him an opportunity to attend treatment for free at NeoCap. He violated again and was ultimately sentenced to prison. So in this matter, the state is recommending 11 months, and we would ask that the drugs and the packaging and the forfeiture specification be forfeited to the appropriate law enforcement agency.
Thank you. This court has reviewed the pre-sentence report and investigation, drug and alcohol evaluation. I consider the facts and circumstances of the underlying offenses, the nature of the offense. I consider what's been said here in court today. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11 of the revised code. For the factors in 29-29-12, there's no factors indicating it's more or less serious. As for recidivism factors, almost all of these factors are present, indicating recidivism is more likely. The defendant was on probation at the time he committed this offense. He's got an extensive criminal history that goes back 32 years. He has been on probation before and has failed to comply with previously imposed sanctions ordered by courts on multiple occasions. And in fact, last time he was before me, despite his history, I gave him a chance at probation. I told him it was 1 shot he had. He violated, and I gave him another shot. And he still violated. Now, I read your pre-sentence report from that 2020, in addition to this one, and you're saying all the exact same things. You talk about wanting to kill yourself, suicide. You talk about you're never going to touch a drug again. And here we are, and I read this pre-sentence report, and it's the same in terms of what you have to say. It's almost the same thing as you said last time. nothing's changed. There's a drug abuse problem that relates to the offense, and he doesn't address it, hasn't done anything to address it. No factors indicate recidivism is less likely. Under 2913B1, defendants previously served a prison term, which overrides the presumption for community control. Prison is consistent with the purposes and principles of sentencing, and there's no way this court can make any finding that he's amenable to community control sanctions. And this is just 32 years. It's over and over and over. This is what it's going to be like. Therefore, it's a sentence to this court that on count 1, defendant serve a term in prison of 11 months. On count 2, serve a term in jail of 180 days. That's concurrent by statute. He has credit for 2 days served on this case, as any other time he's been serving. It's been for municipal court cases that he's been sentenced to. I need to advise you upon your release from prison, you may be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 5.5 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Defendant's for the penal costs. I'm going to order the forfeiture of any contraband or instrumentality set forth in the specification. Ms. Wood, on behalf of the state, is there anything else?
I don't believe so, Your Honor. Thank you.
Mr. Matthews for the defense.
I was just gonna ask a question about, what was that?
No, Your Honor, but apparently Mr. Snyder.
I didn't understand what you said about the transitional control, that's all.
I disapprove any transfer to transitional control.
Okay.
For you is case number 24 CR 1492, captioned State of Ohio versus Donald E. Wolf II. Your Honor, we were last before you on August 4th of 2025. At that time, the defendant pled guilty to one count of OVI, a felony of the fourth degree, in violation of ORC 451119. He ordered pre-sentence investigation and drug and alcohol reports. Those have been completed and submitted for court review. The defendant is present today in court with counsel, Mr. Quinn. We are here for purposes of sentence.
Thank you. 1 second, please. Mr. Quinn, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say at this time on behalf of your client?
Judge, just to reiterate what I said in this pre-sentence report, my client was isolated. He was a caregiver for his brother for several years at his house, and then he died of cancer in November of 24. He was staying at the house, was feeling terrible, missed his brother, decided to go out for a ride and ended up at the bar. Shouldn't have done it. It's very simple. Since that happened, Judge, it's been about 9 months that he has been alcohol-free. He has taken the bull by the horns. He's got alcohol drug assessment, gone to the VA for treatment. He's been diagnosed with PTSD, and he wants to start that treatment as soon as he's available to do that. He's done everything right, Judge, and we would ask that you consider the 60 days. I think the jail treatment program would be a benefit to him. Doing that in person rather than whatever it is that he has to do with the VA. I think contact with other people similarly situated would be more beneficial for him. Thank you.
Thank you. Mr. Wolf, you have the right to address the court before your sentence. You can say anything you'd like. Is there anything you want to say at this time? You can hear me okay?
Yes, Your Honor. I'd just like to say I deeply regret what has happened. Very deeply regret it. And I just want to apologize to the courts, to my family, to the community, and it won't happen again. Thank you.
Thank you. Mr. Quinn, anything else on behalf of the defendant?
No, Your Honor.
Mr. Rhoda for the state.
Thank you, Judge. The state would join in the request for the community control sanctions recommendation at this time, and I ask the court to impose all the mandatory provisions and any other discretionary provisions that are appropriate under the circumstances.
Thank you. Give me 1 second, please. In the sentencing memorandum, Mr. Quinn, you mentioned that he meets with a licensed psychologist once a week to address his chemical dependency.
That's through the VA, Judge. It's like On the computer, right there?
Yeah, it's through.
Oh, that's what you were talking about? That's what's different from...
Being in person.
That's like a Zoom type of thing?
Yes,
That's
sir.
what I would call it.
Okay.
May I address the court, Your Honor?
Sure, please.
Since I was on house arrest for 8 months.
That's right, you're
I
on house
wasn't-
arrest until the plea. I removed that at the plea, right?
Right. I couldn't go do anything, so they mailed me a tablet. They mailed me a tablet that I could do my video appointments through.
Okay, thank
Gotcha.
you.
So that's why you were doing it that way? That's why you were doing it that way?
Yes, Your Honor.
Okay. All right, thanks. The court has reviewed the pre-sentence report and investigation, drug and alcohol evaluation. I've considered the facts and circumstances of the offense involved, the nature of the offense involved. I have reviewed the sentencing memorandum that was filed by Mr. Quinn, taking that into consideration, as well as everything that's been said here today by the defendant himself, Mr. Quinn, the prosecutor, the recommendations. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 2911 of the revised code. As for the factors in 2912, factors indicating the conduct is more or less serious, the court notes that the defendant did cause an accident in this case involving 2 other vehicles. Normal OVI doesn't typically involve an accident involving others. That's what we fear, and that's what the risk is when that happens. But in this case, the defendant rear-ended one car, who then rear-ended another car. Fortunately, no injuries with those, physical injuries with those individuals, but nonetheless did cause an accident involving 2 other vehicles, which makes it more serious than normal. Nothing makes it less serious. As for recidivism factors, the court notes the defendant does have history of criminal convictions. All appear to be alcohol related. I'm seeing a whole slew of disorderly intox, disturbing the peace, disorderly conduct. Obviously a more serious offense back in 2011. He served a prison sentence for. So he does have a history of criminal conduct. In addition, this is his 5th OVI overall. So there's obviously an alcohol problem related to the offense. Now I can't say he doesn't recognize it, and he has taken steps to address it, but it's been a long-standing issue that's caused problems for the defendant for a long time. So factors indicating recidivism, no factors indicate recidivism is less likely. Defendant has previously served a prison term which overrides any presumption for community control, permits the court to impose a prison sentence without having to make any findings for that. I do find, however, at this time that prison would not be consistent with the purposes and principles of sentencing. And the defendant is amenable to an available community control sanction, so I am going to place the defendant on community control sanctions for a period of 2 years. I'm going to order that he serve 64 days in the Lake County Jail He has credit for 4 days, so 60 days remain that must be served consecutively. While in jail, I'm going to order during the last 30 days that he enter and successfully complete the jail treatment program, follow all their aftercare recommendations. Further conditions, you're not to use any drugs or alcohol at all. You have to submit to testing. When requested, those tests must come back negative. Any positive tests for drugs or alcohol will result in a violation a warrant being issued and a violation being filed. You understand that?
Yes, Your Honor.
You're to attend at least 3 AA meetings a week and have an AA sponsor. You're retired now, correct? You don't work any longer.
Correct, Your Honor.
I further want you to attend mental health counseling through the VA, which specifically shall include the trauma processing treatment for the PTSD that you've been diagnosed with, and any other counseling that they think will be helpful or beneficial. I want you to sign whatever releases the probation department needs to, so they can contact the folks there and be updated as to what's going on. I'm going to fine you. The minimum mandatory fine of $1,350 will be the fine. Suspend your driver's license for 3 years. In order that you forfeit any right, title, or interest you have in the motor vehicle that you were operating at the time of the incident. You pay your court costs and supervision fees. Mr. Tompkins, anything else I should be thinking about or I'm missing here?
I don't believe so, Your Honor.
So, Mr. Wolf, you understand the conditions of your community control sanctions?
Yes, Your Honor.
You have any questions for me?
Yes, Your Honor.
What's that?
I'd like to know if I could get my personal belongings out of the vehicle.
It shouldn't be a problem, I don't think. I mean, they're not entitled to those. They've only forfeited, you've only forfeited the car itself, not any personal contents, so.
Your Honor, may I have permission to have my niece get them since I'll be in jail?
I don't know how that works, to be quite honest with you, Mr. Wolf. I have no problem with that, but.
I'll make the arrangements, Judge. I'll contact, it was Bob's. Yeah, I'll contact Bob's and get that done.
I mean, I have no problem with that. The sheriff's department's not entitled to that. So, however, like, you're entitled to the personal, you're definitely entitled to the personal property in the car. So, however that gets arranged, that gets arranged. You want to put that in the entry, that the defendant shall be, personal property in the vehicle shall be released to the defendant or his representative. That should work.
That would be great.
Okay. You have something else, Mr. Wolf?
Yes, Your Honor. About the fine, I have 2 bonds. May I use that for the fine purpose?
I mean, they're not going to apply it. You'll get, the bonds will be released. Why do you have 2 bonds?
One for they said I did a hit skip, which I didn't do, and one for the OVI.
Well, the only,
You got it. Sure.
the bond in this case was $25,000 cash surety, 10%. So I'm assuming you probably posted $2,500 plus maybe some fees or something with that. That's what we have. It looks like it probably was $2,585. Now maybe there was a misdemeanor in Muni Court with
There
this.
was, Judge.
Well, that's.
We'll take it, I'll go over to Painesville meeting and talk to them.
You're entitled to have whatever bond you posted released. And bond, so you get back everything except maybe 10%. There's some fee that goes by statute that I think 10% of whatever you posted gets returned. Once it's returned, you can use that money then, do whatever you want with. pay your fee, pay your fines with that.
So how do I go about paying my fine, Your Honor?
Wait till you get out.
When you get out, you can
Talk
just
about
go,
it.
you can, he doesn't pay it to you guys, he goes to the clerk's office?
Yeah, he'll go to the clerks.
You
We'll,
just-
we'll go over all that with him.
Yeah, they'll review that with you. Probation will be there to help you with that. But you'll just go down to the clerk's office, which is the building right there through that window that you're looking at in the basement, and that's where you can pay that. But when you have, I mean, it sounds like you want to get it taken care of, that's great.
I'm not
But
sure.
you're not going to get it taken care of, I mean, you're not going to be able to address that until you get released from the jail.
Yeah,
I'm not sure how it works. I'm sure I'm going to be taken to jail right now.
Yes.
that's right.
But I
And then when
can't
you're-
put any money on my books, can I? Until the fine's taken care of.
They don't take your money here. That's prison. So when you're in prison, you can't put money on your books because they'll take the money to put towards your costs and fines. They don't do that in the jail. So whatever money's put on your books, you'll have. It's not going to be taken from you to put towards your fines.
So I can take care of the fine after I get out?
Yes. And that won't impact you in jail in terms of having commissary or anything like that.
Thank you.
Any other questions? Mr. Wolf?
No, just,
I need to advise you that if you fail to comply with any of the conditions of your probation, the rules of probation, which the probation department will go over with you, if you leave Ohio without permission from the court, or if you commit another offense while you're on probation, a motion to terminate your community control sanctions will be filed. If it's found that you did violate, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you. Or I could terminate your probation and send you to prison. If I did that, it would be 30 months in prison. So that's what's hanging over your head. You understand that?
Do you understand that?
oh, yeah.
Yes.
Yeah.
Yes?
Say yes.
You have to respond
Say
verbally.
yes.
Yes, Your Honor.
If you do understand it, don't say yes if you don't.
He understands, Judge.
All right. All right, Ms. Nerode, anything else for the record?
Nothing further, Judge.
Mr. Quinn.
Go with you.
Mr. Quinn, anything else?
No, Judge.
Thank you.
Judge, real quick, Scran can be removed, I'm assuming?
Yes.
Okay.
Yep. Bond's released, that's part of bond, so.
Okay.